Welcome, everybody, to today's webinar on survivor-centered reparations. My name is Chris Esdale, and I'm a senior legal advisor at Redress, and we're really delighted to have you with us today. Firstly, just in terms of housekeeping, simultaneous interpretation is provided in French and Spanish and Arabic, and at the bottom of your screens, you should be able to turn this feature on, choosing the language that you prefer. You won't be able to use the mic function, but down at the bottom of your screens, you'll see a question and answer chat box. So please write and send your questions and comments there, identifying yourselves if possible, and you can send the questions as the panelists are speaking. And we'll collect all the questions, group them together if needed, and we'll use them in the Q&A. And you should also find now a poll at the bottom there for you to answer about the knowledge that you already have on these issues. So now I would like to introduce you to Azul Rojas Marin, a Redress client, a human rights defender, an activist, and herself a survivor of torture. Azul is the director of the Blue Hearts, or Corazones Azules Foundation, and is, excuse me, is currently studying law at the Technical University of Peru. Azul is a transgender woman who was arbitrarily arrested by police officers in 2008 and then was a victim of torture and sexual violence. Redress, together with Peruvian NGOs Promsex and the National Coordinator for Human Rights, helped Azul to take her case to the Inter-American Court of Human Rights, which issued its landmark judgment in 2020 and found Peru responsible for the torture and sexual violence that Azul had suffered. The court ordered various forms of reparation for the harms caused both to Azul and to wider Peruvian society, including the payment of compensation, a public apology, a criminal investigation into what happened, provision of the necessary medical and psychological treatment, and the adoption of measures aimed at ensuring that what happened to Azul shouldn't be repeated, including running training programs for all officials who have contact with LGBTIQ+ victims of violence. In 2022, government ministers in Peru acknowledged the state's responsibility for what happened and formally apologized to Azul at a ceremony in Lima. Azul will now share some opening remarks and highlight the importance of reparation for survivors of torture. Over to you, Azul.
Buenos días a todos y a todas. Gracias por la invitación en un tema tan importante como nos acoge a todos y todas, el tema sobre las reparaciones sobre las víctimas. Siento que hoy en día estamos abandonadas por nuestros gobiernos, por nuestros estados, nuestras políticas públicas, no están acorde a las necesidades de las personas, o mejor dicho, del grupo vulnerable, como somos las personas de la comunidad LGTBI. Como una sobreviviente de actos de tortura y violencia sexual sufridas en el 2008, hoy en día, si bien es cierto, hay una sentencia emitida por la Corte Interamericana de Derechos Humanos, donde hay una serie de reparaciones que hasta hoy en día el Estado, muchas de ellas aún no ha cumplido. Si bien es cierto, ya ha cumplido con el acto de reconocimiento de responsabilidad internacional y disculpas públicas, hay otras reparaciones, como son unas reparaciones muy importantes, que son el tema de la salud, el tema de los estudios, el tema de las sanciones, el tema de los pagos, de las indemnizaciones. Quiero acotar aquí el rol fundamental que cumplen las organizaciones y agradecer también a Redress, a la Coordinadora Nacional de Derechos Humanos, a Promsex, que han venido todos estos 15, 16 años acompañándome y apoyándome en este proceso para que mi caso pueda llegar a la Corte Interamericana de Derechos Humanos. El rol que realizan, un rol muy importante, muy fundamental, el acompañamiento, no tan solo un acompañamiento legal que hacen las organizaciones, sino también el acompañamiento emocional como lo vienen haciendo conmigo y con las demás víctimas. Las reparaciones para una como víctima tienen que ser acordes a la necesidad de la víctima. O sea, en otras palabras, no pueden venir unas reparaciones que no van a de una u otra manera reparar los daños que nos han ocasionado. En mi caso, por ejemplo, el tema de los estudios, yo dejé de percibir mis estudios hace más de 15 años por lo que me pasó. Sin embargo, quiero reconocer también que una entidad privada como es la Universidad Tecnológica del Perú me brindó una beca integral al 100% de estudios. Esto es para de una manera como víctima poder reincorporarme, resarcirme a la sociedad y además mi proyecto de vida continúe, ya que si bien es cierto, estas reparaciones al 100% no van a hacer olvidar los hechos que nos ocurrió hace muchos años. Decirles también a las víctimas que aún han sido invisibilizadas, víctimas que aún no han sido reparadas, no han sido debidamente reconocidas, que tenemos la esperanza de que, si bien es cierto, es una lucha, pero esta lucha no la hacemos solas. Esta lucha está acompañada, como lo vuelvo a decir, con muchas de las organizaciones, ¿no? Y nuevamente agradecerle a Redre, a PRONCET y a la Coordinadora Nacional de Derechos Humanos, que gracias a ellos mi caso ha llegado hasta la Corte Interamericana. Hoy en día estamos trabajando de manera conjunta para que esas reparaciones se puedan cumplir y eso quede un precedente para en continuación para los casos que puedan venir posteriormente y que estos actos repudiables, estos actos execrables que ocurrieron conmigo no puedan quedar impunes. Muchísimas gracias.
Asul, it's lovely to see you, and thank you so much for delivering those opening remarks. It's such a pleasure to have you with us as part of this webinar today. Through our litigation experience at Redress and through our conversations with clients such as Asul, we understand that there is not a one-size-fits-all approach to seeking justice and reparation. Survivors of torture exist all over the world. They vary in many ways, including their age, race, socioeconomic background, their religion, their gender identity, and thus have different experiences, different perspectives, and different needs. It's crucial that survivors are placed at the center of justice initiatives and reparative processes, so they are treated with dignity and respect. Reparation processes inevitably carry some risk of re-traumatization, not least because they tend to be very lengthy, but the legal process itself can also be very demanding and uncertain. Our experience suggests that we can take practical steps to prevent or at least reduce risks of re-victimization and re-traumatization and support survivors' empowerment. Our understanding of a survivor-centered approach is one that puts the rights, needs, and dignity of survivors, including their well-being and safety, at the forefront of efforts to respond to human rights violations. The purpose of a survivor-centered approach to human rights litigation for reparation is to ensure participation, to reduce the risk of further harm and re-traumatization to the survivor, and to reinforce their agency and self-determination. This webinar seeks to explore what a survivor-centered approach to reparation can look like in practice. We are delighted to have an expert panel of speakers from Latin America, Africa, and Asia who have supported survivors of torture in their journeys to obtain reparation. Our discussion will include contributions from Dr. Delia Sanchez de Angel, Global Reparations Study Lead at the Global Survivors Fund, Dr. Ayo Sogunro, Sexual Rights Lawyer at the Initiative for Strategic Litigation in Africa, and Mandira Sharma, Senior International Legal Advisor at the International Commission of Jurists. They will discuss both opportunities and challenges that can arise during the process of seeking reparations for torture, as well as lessons learned to enhance best practices. As part of our internal reflections on a survivor-centered reparations practice, we have published 2 new practice notes that capture our thinking on these issues: Reparation for Torture Survivors and a survivor-centered approach to seeking reparation for torture. Before giving the floor to our speakers, I would like to invite my Redress colleagues Alejandro Rodriguez Diaz, Legal Officer, and Camila Marin Restrepo, Communities Officer, to briefly introduce these two practice notes. First up is Alejandro. The screen is yours, Alejandro.
Thank you, Grace. Hello, everyone. My name is Alejandro Rodriguez, and I'm a legal officer at Redress. I would like to present the Reparation for Torture Survivors Practice Note, which is the first publication for a series designed to support the implementation of reparation awards on behalf of survivors and victims of torture. This document will be available in principle in English, Spanish, French, and Arabic. This guide is aimed at facilitating the understanding of reparation and its many facets, principles, and standards, and contributes to the strengthening of a community of practice on implementation of reparations. It provides practical and also comparative examples related to claiming and accessing reparation in different contexts, such as armed conflict, in a survivor-centered manner, and proposes strategies to overcome obstacles in the journey towards reparation. This practice note has three main sections. First, the right to reparation. This section describes the concept of reparation, its principles, forms, and who is entitled to redress, for example. The second section is the state's duty to deliver reparation, which lays out the international legal obligations regarding effective investigations and prosecution of perpetrators, the provision of effective remedies for victims to claim reparation, and some practical comments when the perpetrator is a private actor. The final section is the practice of reparation. This section explores the most common challenges that practitioners and also victims face in law and practice for accessing justice and reparation from a domestic perspective, including material, legal, and contextual obstacles. I will hand over to Camila for the presentation of the second practice note.
Hi everyone, my name is Camila Marin Restrepo and I'm the Communities Officer at Redress, and I would like to introduce the second practice note of the reparation series, which is called A Survivor-Centered Approach to Seeking Reparations for Torture. This practice note is based on Redress's experience of obtaining reparations, as well as desktop research and consultations with 12 practitioners from national and international organizations that have in-depth reparations experience across various domestic and international human rights mechanisms. This practice note delves into each of Redress's 9 principles of a survivor-centered approach, which include do no harm, non-discrimination, confidentiality, informed consent, managing expectations, and a few others. The practice note also provides practical guidance for their implementation and explores lessons learned to enhance best practice. I would like to first of all thank the organizations that took part in the development of this practice note, and they shared their valuable experience with us at Redress. So thank you. We also acknowledge the vital work that these and many other organizations in the Global South carry out with survivors on a day-to-day basis. Their experiences have been a significant source of inspiration for us at Redress in progressing our own survivor-centered strategic litigation and reparations practice. And also, whilst this practice note provides some useful guidance based on experience to date, it is important to acknowledge that practices in this area are constantly evolving, and it is essential to emphasize that there is no singular, universally applicable approach. The relevance and the methods of implementing these principles can differ based on the specific context and corresponding circumstances. So the links to the practice note have been included into the chat, so please feel free to have a look at these after the webinar in your own time. So now, sorry, we're going to move on to the panel, and we're going to have a very interesting conversation with some of our esteemed panelists. So we have Dr. Delia Sanchez del Angel, Dr. Ayo Sogunro, and Dr. Mandira Sharma. And just to remind everyone, if you please send in your questions or any comments using the questions and answer box at the bottom of your screens, and we'll be collecting these as the conversation progresses. So I'm going to start the discussion today with Dr. Delia. Delia is the Global Reparations Study Lead at Global Survivors Fund, and her role is to coordinate critical and survivor-centric research conducted in collaboration with local and international partners. As a qualified lawyer and with a PhD in human rights from the University of Essex, Delia is passionate about researching victims and survivors' participation and their rights to justice, truth, reparation, and guarantees of non-recurrence. Delia, thank you for joining us. We're delighted to have you here. So, given your extensive experience working on reparations within both a Latin American and a global context, what do you think are the most common mistakes that reparations practitioners make when engaging with survivors, specifically in relation to the implementation of reparations? And what would be your 2 top tips to avoid such mistakes?
Thank you for the question, Camila. Very happy to be here with all of you. Well, focusing on the time a reparation claim has reached the implementation stage, acknowledging what Chris and all of you have mentioned, it has been a long process, complex and exhausting in most cases. Based on that, there are what I will say 2 common mistakes, although there are many more, but I will focus in 2. 1, not having a conversation with survivors about this new phase of the reparation process, what it entails from a procedural and legal standpoint, but also in relation to the political context. The implementation of reparation measures heavily depends on the existence of adequate legislation, mechanisms, resources, and of course, political will. While dialogue between survivors and practitioners should start at the very first stage of the reparation process, the litigation, and continue all throughout it, it is very important, and as you rightly so mentioned it in the practice note, to touch base with survivors at key milestones of the process. And the start of the implementation is one of those. A transparent dialogue and constant dialogue is essential. I remember years ago reading the works of Rogelio Goiburu, the son of a victim of arbitrary detention, torture, and forced disappearance. After the Inter-American Court had issued the judgments against the state of Paraguay in 2006, he expressed his frustration and disappointment over the litigation process. Why? Because he had believed that the Inter-American Court had coercive power over the state. When he understood that that was not the case, that having a reparation order wouldn't mean that he will immediately get reparations, he felt that the court and the whole process had been useless. While the frustration over the lack of compliance or full compliance of reparation orders may not be avoided, having a honest, clear, and ongoing dialogue with survivors and their families can definitely help. It helps to understand the process, its limitations, and also manage expectations, which can mitigate a bit of the emotional impact. It can be difficult and costly also, depending on specific circumstances, but it's also a good practice to ensure psychosocial support, not only during the litigation process, but also before it starts, and also after a judgment or decision that has been achieved. Another common mistake that I will quickly say that is also linked to communication. During the implementation phase, stopping communication or reducing communication with survivors is a very serious mistake. I have been speaking with victims and survivors of different human rights violations, including torture, and when the lawyers stop communicating and they don't understand why, the feelings of betrayal and abandonment resurface. So it is essential that survivors and their representatives reach an agreement on the manner and frequency in which they will be communicating during this stage. It is sad that when the litigation process was done with a survivor-centered approach, but we reached the implementation of reparation stage, and then communication stops. In a way, for victims, we are again re-victimizing them if we stop this communication. I will leave it like there. Thank you.
Delia, there's some really important points, especially on the need to have these conversations at different stages, not just, at the beginning, but throughout, and then after the implementation as well, and reaching that agreement. I just wanted to follow up with a second question. So, as you know, sometimes the priorities of human rights organizations, lawyers, and survivors can sometimes differ. So how can reparations practitioners and organizations avoid utilizing survivors during human rights litigation and reparation processes and ensure that survivors' needs are always prioritized?
Thank you, Camila. I believe this is such an important question. I will focus on 2 points for this answer. One, it's very important to acknowledge survivors' agency and expertise. Second, transparent and honest communication, which includes the setting of expectations. To conduct survivor-centered reparation, survivor-centered reparation, but survivor-centered litigation, it's crucial that practitioner organizations engage with survivors as partners in the process, not as passive subjects of the litigation. There must be an acknowledgement that their rights, needs, and dignity have to be at the front of the process. It is vital that we as practitioners recognize survivors' experience and expertise. They don't only have first-hand understanding of the torture or other human rights violations that were perpetrated against them, and on the harm that was generated against them. They also have the right to shape and decide on the processes that will impact their lives. A lack of familiarity with legal processes or concepts should not create an imbalance of power where the lawyers know better than the survivor and the survivor only hears about the lawyer's decisions without having any say. Lawyers can work with survivors, they can learn from each other and mitigate this imbalance as much as possible. It's important, despite procedural regulations of tribunals and mechanisms limiting the participation of survivors, litigants and practitioners can make sure that survivors participate from the inception of a case, and to the several processes of decision during the case, and then onto the implementation of reparation. It's important also that, as I had been mentioning, transparent communication with survivors, along with an understanding and commitment from practitioners to adapt the strategies in response to survivors' feedback. Then I would say, while survivor-centered litigation, litigation is key, and we of course want to set precedents. Survivor-centered litigation can not only be about setting a precedent or about a particular agenda. Therefore, organizations, lawyers, and other practitioners involved in the reparation process need to accept that while they will advise and accompany survivors, the survivors' wishes may not sometimes align with their own. A survivor might decide not to present a claim, or after years of litigation decide they don't want to continue with the process. I have also talked with victims that decide after years that they want to reach a friendly settlement settlement agreement, and that's perfectly okay, and respecting their wishes while informing them of the consequence of any given decision or action is the only thing that lawyers and practitioners can do to remain survivor-centered. Thank you.
Thank you, Delia, and you did a great job of summarizing such complex, conversations. I'm sure we could spend hours here talking about this. So thank you. I understand it's a short time that we have today to speak. So great, thank you. Now I'm going to be introducing our next speaker, Dr. Ayo Sogunro. He's the sexual rights lawyer at the Initiative for Strategic Litigation in Africa, also known as ISLA. Ayo is a lawyer, a scholar activist, and a writer, and his work looks at the protection of the rights of marginalized groups in Africa with a focus on the rights of sexual and gender minorities, particularly through the law and strategic litigation. He has an LLD in Sexual and Reproductive Rights from the Center of Human Rights in the University of Pretoria, where he has also served as the project manager for the Sexual Orientation, Gender Identity and Expression and Sexual Characteristics Unit of the Center for Human Rights before joining ISLA. Ayo, welcome. Thank you so much for being here. So you have worked extensively with sexual and gender minorities, many of whom are survivors of sexual and gender-based violence and face stigmatization and ostracization in their communities. Could you tell us how you adjust your approach to seeking reparations when working with vulnerable survivors, such as victims of sexual and gender-based violence?
Thank you, Camila. Essentially, we work in a context where there is a lot of hostility and a lot of discrimination against members of the community that we work with, the LGBT community in particular. And so our approach has always been right from the outset to center survivors and the community, seeing the community as a whole also as our clientele. And we've seen several situations of predatory lawyering where legal professionals try to take advantage of survivors because they believe they have very few options. They cannot go to the police. They cannot go to, anybody else. Nobody wants to touch this case because they feel it will jeopardize their legal careers. So we try to ensure that the lawyers, first of all, that handle cases are lawyers that are part of or at least understand the movement. So they come to the case not just as legal professionals, but as people who have been trained in and sensitized on the goals of and the issues affecting the LGBTIQ plus community. And when it comes to particular issues of reparations for survivors of sexual and gender-based violence, we try to ground our litigation in an approach that takes into account the domestic context, what are the legal situation and what's the legal situation on ground? Is this a context where security and the safety and well-being of the survivor is going to be jeopardized? We try to look at the local advocacy movement. Are there NGOs that support and can support the process? And how can they contribute? What kind of advocacy can they help to bring to the case? And then, of course, the unique needs, circumstances, and the safety of each survivor that we representing. And so this customization process begins with recognizing the holistic needs of the survivors beyond the immediate legal representation. And we have what we call our basket of care process, where we try to include psychological, medical, and socioeconomic support for the survivors. And as a general rule, we try to adhere to a trauma-informed method so that we ensure that our interactions do not continue to exacerbate the survivor's trauma. And we ensure that our team gets this kind of constant sensitization and periodic training in-house. Sometimes we bring external experts who come to also share the issues. And the point here is just to ensure that the lawyers who are handling the cases are essentially people who are also part of the work that the movement or the client or the community as a whole is trying to achieve. And that ensure that our work does not stigmatize further and that our strategies, ensure that the risks that are likely to ensue from the process do not exacerbate or at least mitigated.
Thanks, Ayo. So in your answer, you spoke a bit about, collaborating as a movement and with different organizations. And that's something that we think is very important as well. You've touched upon the types of support that, in your work, you try to provide to your clients and survivors. I was wondering, some survivors may request or need different types of support. So not just the psychological accompaniment, but they may have other needs as well. How do you think reparations practitioners can assess this in a sensitive manner? And, how does this align with organizational capacities as well? How can they discuss their capacities with clients, for example?
I mean, to be honest, it really can be a very, very nuanced and sometimes even difficult situation to walk through. And for example, in our own case, because you are principally a litigation NGO, we are lawyers, we have to be very transparent about our capacities and limitations so that survivors have a very realistic expectation. We've had situations in the past, a couple of cases, where it was clear when assessing the varied needs of the survivors involved that they wanted some kind of, you could say, private support rather than legal redress. And it's like we have this dialogue, and what comes from some instances is that they believe that the cost of the reparations process itself in terms of emotional, mental, even material toll, it's often more, or it seems more than it is worth for them to go through. And remember, we are working in contexts that are extremely hostile to this kind of process in the first place. So we have had litigants who, after this kind of conversation, they decided that, look, what we really want is safety. What we really want is well-being for ourselves. And we don't reasonably foresee this being readily available through this legal and political process. So what you want is a kind of just private care, so to say, rather than public or legal action. And then what we do then is, we refer them to, again, NGOs in our networks who actually will have that expertise and capacity to provide this. And then when we see people who say, look, we are ready to go through it, and we also want support in terms of both material and security needs, then we also provide this. Sometimes it even involves relocation, having to move from where they are to another place until the litigation process at least has taken a life of its own. So for us, we believe it's just important to listen attentively to survivors, respecting what they want and, ensuring that they're actually able to identify and we are able to give what they've identified as the support they need.
Thank you very much. That's very interesting. And now, and lastly, but in no ways least, I would like to welcome Dr. Mandira Sharma. Mandira is the Senior International Legal Advisor at the International Commission of Jurists. She is also a co-founder of Advocacy Forum Nepal. She is a lawyer, an activist, and a human rights defender who has worked extensively with victims of human rights violations from the Nepali Civil War. She has designed strategies and implemented programs on litigation, advocacy against impunity, and transitional justice issues. She has also trained many human rights defenders and lawyers, both nationally and internationally. She has a PhD from the University of Essex and was awarded Human Rights Watch's prestigious Human Rights Defender Award in 2006. Mandira, welcome. As I'm sure you know, litigation can often be very lengthy and span a long amount of time. From your experience, how do you manage survivor expectations over such a long period of time?
As previous speakers stated, I think it depends how you prepare your clients, how you engage with your clients. Especially in the context of Nepal, impunity is so entrenched. And to get justice is very difficult kind of endeavor for any survivors. I have worked quite a lot with victims of torture as well, as we do monitor places of detention and document cases of human rights violations, including torture. We actually do not have, it's changing. I will come back to that if time permits, but as of today, as we speak, we do not have the law or legal framework that would provide reparations, or that reparation is still to be recognized as victims' right. But what we have, for example, is Torture Compensation Act in relation to the cases of torture, where victims can bring the civil lawsuit claiming compensation. If the court finds violations, then court offer compensation for victims, which is about $800, 100,000 Nepalese rupees. So from this perspective, it's not a sort of reparation for victims. Even then, I have worked with many survivors who really wanted to bring their case under the Torture Compensation Act, as this is the only available remedy for them. And then pursue this because they think that it is important to challenge the unjust that they suffered, and also to recognize that harm was caused to them. So in this process, of course, it's not a sort of big amount of money. It's not proper reparation. It's a lengthy process. Of course, victims do get frustrated as well. Sometimes they have a lot of other needs as well, medical needs, other needs. But it's very important that you explain everything to survivors beforehand. What are the limitations? What is the procedures? And bring them along in this journey. When you design any strategy on litigation, I think victim survivors should be part of that strategies. So I have been in a number of situations where survivors themselves are the sort of lead, and they do actually chase lawyers to follow up on their cases, providing a sort of source of energy for many defenders and lawyers to take their cases up. So from these perspectives, I would say that litigations, lawyering in other traditional criminal cases or any other corporate cases is different than doing lawyering litigations in human rights violations cases, especially torture, for example. We sometimes do not have this kind of office hour kind of system, because you are the first contact point for survivors. Their lawyers are the first contact points for survivors. So they actually do call you early in the morning, late at night. So they expect you to be ready to respond some of their concerns when they arise. Of course, we explain, but nevertheless, this is the context that we work in. So I think from that perspective, I would say that we need slightly different strategies when we litigate human rights violations cases, where victims' interest, their decision, their guidance in the litigation strategies is very, very important. It's not only the litigations, because along the litigations, we also do a lot of other advocacy as well, and they have to be part of it. In this process, they also get empowered, because along the way, they also learn many things, and we also learn many things from them. And that also informs and helps to design the strategies as we move forward. So it's lengthy process. I have been into the situation, or I have been taking up cases that has taken 17 long years, but family members, the victim's family are the one to really continue to take the torch. So it depends, like how you engage, how your relationship with the client.
Thank you, Mandira. You've mentioned some really important things about, co-designing strategies involving the survivor or the survivors in that strategy development, and the point about being able to learn from them, having a process where it can be mutual. So that's really important. I understand that the communication and being the first port of call also is something that allows you to build trust with your clients. So I was wondering, is there anything else that you consider that practitioners can do to build trust with clients, with survivors?
I think, as I said, that sort of relationship is very, very important. As for example, in our context, many survivors tell us that I cannot share this with anyone, even to my husband, or especially in the case of rape. But I'm sharing this with you. So they are not able to share this with anyone, but they do share this with their lawyers. They do share this with us. So they also have a lot of other needs as well, medical needs, other psychosocial support that they need. They have other needs as well. So I think lawyers are also a kind of liaison for them, between the survivor and also other service providers. So we don't only provide them legal assistance or legal counseling. We accompany them in this process. So it's also accompaniment as well, and linking them with other service providers as well. In some cases, they also have security concerns, and it's again, lawyers, they have to also consider that factors as well. Once you design the security measures or strategy in responding to the security need, again, survivor has to be in the process of designing that strategy as well. So what we do, which might also be useful in other contexts, is that mostly the survivors who come from lower socioeconomic kind of startup society, they actually do not have any voices in the society. So one of the strategies, as part of our litigation strategies, we also have a strategy for advocacy and empowerment of victims as well. So for example, if there are issues where survivors come from that kind of society, and their voice is very important, or the recognition is very important at the local level. We also organize sort of platform forums to discuss various human rights issues, where survivors are also invited as the guest to sit next to the high-ranking officials in equal kind of status. These are something that we learn along the way, actually, because some of the survivors were saying that, first time in my life, have been able to sit next to the chief district officer, because in the past I have called him several times. They would not pick up my phone, but now if I make one call, now they know me, so they receive my call. So I think the strategies, the litigation strategies, should also accompany by other advocacy and empowerment strategy as well. So once you bring survivors along these processes, I think it also empowers survivors as well and enhance the trust between your clients and the lawyers. The other thing that I wanted to share, having said all this, of course, there are limitations as well. Of course, we don't take any fee from our client, but we do depend, because we do work for organizations, and we do depend on the fundings. Sometimes, this litigation process takes many years, and we may not have the fundings. So one of the concerns, that or one of the challenges, or one of the issues that impact the relationship between your client and yourself, or lawyers and clients, is because of the discontinuity of the services. If the lawyers discontinue their service because there is no funding, then it really undermines the trust. So somehow, from that perspective, I would again say and stress that the client and lawyer's relationship in human rights related cases is slightly different than in other corporate cases or traditional cases, criminal cases. For example, in other corporate houses, in other litigation work, I would say that you are not able to pay me the fee, that's in, I end my service here. But here, it's not like that. So somehow there is certain personal and institutional commitment involved into this work. And if you have also understood this and taken this into consideration, so once you embark into this litigation work, I think that also helps to enhance the trust between your client and the lawyers. And this is what we have again learned in this process, and we now incorporate this or consider this into our work.
Great. Thank you, Mandira. So in terms of time, I think we probably have around 10 minutes to take, say, 3 questions from the audience. Some people have sent their questions in already. We have one that I'm going to give to Ayo, which is the following. So this question's coming in from the Human Rights Development Center, who's working for torture rehabilitation and torture prevention in Bangladesh. So HRDC is also working for protection of LGBTQI rights, and these groups have been facing difficulties in Bangladesh. So they are asking how to protect the survivors of these groups, which is quite a broad question, but if there's anything that you could share in relation to our conversation today, that would be great. And then I'm going to follow up with a question for Delia. I think what would be interesting is if you could explain a bit about how, as practitioners and litigators, we can help maintain the morale of survivors when the pursuit of justice is prolonged, and how to balance that sense of that need for hope that is required when pursuing justice versus the reality of, what pursuing justice can actually be like with such long timeframes. And then I'm going to ask a question to Mandira, but maybe if we start off with these two, and then I'll follow up with Mandira's question after. So Ayo, please go ahead.
Thank you very much. So like you've mentioned, that is a very broad question. But I'm going to take it from the approach of what this conversation has been about, and which is about centering the survivors in this context of reparations and process. I think it's important, to distinguish between issues of the individual and issues of the community as a whole. And I think in a lot of these kinds of hostile circumstances, what we find is that it's often difficult for an individual to be able to effect change through the legal system or through the legal processes, unless the individual already has some kind of privilege, maybe the educational background, or maybe their social or economic status is able to, help to push that or propel that forward. But for the majority of people who tend to be the victims of the kind of violence and torture that we're dealing with, they don't even have that kind of privilege in the first place. So they cannot even use their personal circumstances or their own personal abilities or capacities to push through. And that is where community comes in. And I think that's the important thing, or the important feature we've seen in the work we do, is that there is a need for strong movements, strong communities of individuals who are able to highlight and focus on the issues that affect the community as a whole. Because the violence that is being done to an individual is not being done because of that individual, but because of the identity that they have, which is a communal issue. And so the necessity of building strong communities through movements becomes like the key point. And it is through this movement building that we are then able to strengthen the capacity to litigate successfully, to have welfare and support groups that are able to take care of victims who are survivors who are going through this reparations process, and also to be able to have the kind of advocacy that is able to bring awareness to the wider public of what these issues are and how they impact even the rule of law and democracy, generally speaking. And so I would say that, yes, like I said, it's a broad question, but for me, that's community support and movement building, and the use of lawyers, of course, who are parts of the movement, to understand what the movement wants, is the most critical way to proceed. Thanks.
Great, thank you, Ayo. And just to say to everyone, we may not be able to get through everyone's questions, as it has been quite a interesting discussion. So apologies if we don't answer your question, but I'm going to move to Delia now. Thank you.
Thank you very much, Camila. So the question is how to keep the morale when it's such long process. Well, this is very difficult, of course, and it depends on the context we are in. Speaking with women, victims of survivors of conflict-related sexual violence that have been waiting in many countries for decades and facing not only impunity for what happened to them, but many times are isolated from their own communities, keeping the morale through the litigation process, and then actually also during the implementation process is extremely difficult. But I'm thinking key, as I have been mentioning today, continuous communication with them, transparency and honesty. Also for the civil society organizations and lawyers, this process is difficult too. During the years, like Mandira was saying, funding is a big issue that organizations and lawyers face, but being honest with survivors is important. Also, what I have been discussing and talking with different survivors and practitioners is that it's fundamental not to focus only on the litigation process, but do also other activities, as Ayo and Mandira also mentioned, like advocacy, working with community, because there are other different kind of wins besides the one you achieve at a tribunal or at an international or national. It is important what communities think, also what's happening to them. And for example, in the case of CRSV, if your community is now accepting you, the process may be long, but you are not isolated and you are part of it. So training, workshops, also facilitating places where survivors can interact and talk with each other, creating support networks also helps maintain the morale, because you don't feel anymore alone. You feel you are part of other people that are also fighting with you and for you. And that has been crucial with many of these women that I have met that have for decades worked and continue fighting. It is hard. Many of them say, I don't want to die before I see reparations become a reality. Many of them that I have met are in their late 70s, 80s, and it is very hard, but they maintain hope. However, when community support and network and being listened to by others and by organizations continue, supporting them with advocacy mechanisms, there are many other ways that we can do. So I think we need to be creative. We need not to leave everything to the litigation process. We need to work through other different venues, and that will help survivors to continue hoping that justice will be a reality at some point. Thank you.
Thank you, Delia. And I agree, because I think many times litigators just see the kind of end moment as being the point where empowerment and, you know, joy takes place. But in fact, the litigation process, there can be many, many moments of, you know, just like there are ups, there may be downs as well. So very important point. And just before I ask Mandira, as we started a couple of minutes late, we're wondering if we can go over for a few minutes. So if everyone's willing to stay for 5 minutes extra, just because I feel that the conversation is getting really interesting and it would be a shame to cut it off right now. So now I'll move on to Mandira. There's a question from the audience. So what are some of the security strategies that can be used in litigation, especially in cases of conflict-related sexual violence where confidentiality is key?
This is actually a very important question. We are actually struggling to find a sort of solution to this problem. But I think we have been adapting different strategies. One of such strategies is that, you know, we actually do not have any process as of today that would ensure CRSV's access to justice, access to reparation, access to truth. We are in the process of, having a sort of legal framework in place for transitional justice process. Addressing CRSV is one of the issues, although we do have National Action Plan and Security Council Resolution 1325/1820. But how do we collect information? How do we store this? How do we ensure survivors' access to reparation without undermining their confidentiality? Their security is a key challenge. And we are continuously actually seeking sort of different ideas, different strategy around this issue. So one of the issues, for example, or one of the strategies that we are discussing now in the context of Nepal is to have localized system in place where survivors themselves are the one to be part of the committee that collect information relating to CRSVs. As this is localized, this is something that National Action Plan on Security Council Resolution 1325 and 1820 envisions to encourage CRSVs to register their case. But one of the concerns that we have started to hear now is that, this is not going to work because we don't feel secure because our community is so small, and confidentiality will not be maintained if I go to this committee. So they are suggesting that, the survivors are suggesting that we need something central, maybe a little bit removed from our hometown. So these are the learnings that we have. The other strategy that we have, for example, is that whenever we have issues, discussions, or whenever we have to invite CRSVs, we invite them as conflict survivors. The conflict impacted people differently. There are different kinds of victims. Like those who were displaced, those who were tortured, those who were, whose family members are disappeared, all are put into the categories of, conflict survivors. So they do participate in all these different forums because it's very important that they also participate in these forums and these convenings and have networks with other survivors, but we do not call them in a separate forum, which is for CRSV, for example. It's like a platform for conflict victims where they also join. This is to protect their identity, because in many cases they say that I don't want her family members to know, I don't want my community to know. The other strategy is that we have been documenting cases. There are now loose kind of networks of survivors. They themselves help each other to document their stories, refer the cases to service providers, especially for medical treatment and psychosocial support. So these are some of the strategies that we are using, but we are still working on what is the kind of viable security strategy for survivors. So it's continuous kind of work, I think.
Thank you, Mandira. And what I will do now is I'll give one final question, and the panelists can just give, maximum of 2 minutes answer to the question, and each of you will hopefully have something to contribute. So this question is from Polat from the Human Rights Foundation of Turkey. He is asking about the challenges of advocating for reparations measures other than compensation, but maybe we can focus the answer specifically on any strategies and tactics to push authorities for a holistic approach to reparations. I think that's a really good question. And just to say that we will be able to answer any unanswered questions by email after the webinar. So we could go in the order of Mandira, Delia, and Ayo.
This is again a sort of continuous battle for us, but I think we have also come, far, on this issue. First of all, recognizing reparation as victims' right is important, and having a sort of legal framework that recognizes that reparation is not just the monetary compensation, because this is the issue in Nepal, because reparation is understood as if it is the monetary compensation. We had to have civil society organizations had several rounds of meetings, discussions, awareness raising kind of campaign to really unpack this issue, what reparation really entails, why this is important for the victims to have recognitions, why it is important for the state acknowledgement, why reparation is also, not only individuals, community as well, why memorialization is important. So I think it has taken us many years, and it's continue. We continue to advocate for a holistic approach to reparation. But I think communications and constant kind of engagement with media, with different actors, political actors, grassroots people, even the civil society organizations, even the victims, it's very, very important. So now we have the draft law that recognizes reparation as victims' right, and it also incorporates all different components of reparations, but that this bill is yet to be approved by the parliament and implemented.
Okay, thank you. And Delia?
I will add just a bit to Mandira's excellent answer. It is, of course, in each country and each context, this is different. In many countries of Latin America, this battle started many, many decades ago, proving that compensation goes beyond, reparation goes beyond compensation. I think it's key to engage with authorities, but also with other civil society organizations, because I find in some countries, civil society organizations also perpetuate this discourse of compensation being reparation. So we need to do like a work not only with authorities, but also with other practitioners and sometimes also survivors themselves. Showing good examples from other countries and how it has impacted favorably like the lives of survivors, how it made reparations more sustainable, not only to focus on compensation, it is key. So I will encourage to liaise and find contact people from other countries, from other successful experiences, and use these examples when advocating with authorities, because sometimes with government you need to show and you need to prove reparations are more than compensation, and reparation can transform and change lives. And this is the evidence, and you cannot deny it. So I think it is key, and there are so many good examples all through the world of how, after decades, sadly, of a lot of fight, we have been able to prove that reparation should be holistic and can also be transformative. Thank you.
Thank you, Delia. And just to finish off, Ayo.
Thank you. So yes, of course, I support what Mandira and Delia have already said, but I think that in certain kinds of contexts, like some of which you work, this can be very difficult. But I think the nature of the issue that is being brought before the courts, for example, can be key into unlocking certain methods of reparations. For example, we have a case of a soldier who tortured a trans woman. And we took the military, the government, and the soldier to court. And the soldier attempted to contact our client and to make to settle it privately and make a private apology. And the military was basically saying, but you see, it's not our problem. It's between the two of them. And we insisted that no, there are certain things we want. We want, for example, the government to hold the soldier accountable by ensuring that there's appropriate discipline. What they did originally was they gave him, I think, like a month's suspension or something like that, because it was a trans woman, so they didn't really care. But we said, no, we want proper holding of the person accountable, a proper process. And then secondly, we said, look, if we are going to settle it, we also need the government to issue a statement, a public statement, stating that this issue is condemned. Attacking people on the basis of their identity, of their sexuality or gender identity is totally wrong, and ensure that there is a change in attitude and some kind of sensitization for especially people who are in public office or public facing positions. And we said that, look, what we are interested in is not just this kind of we are sorry it happened, but we need to see that there's a legal change and a social change coming out of this. Of course, well, they denied, they did not want to go down that route with us privately. So we said, then, we'll keep going to court and we'll see what the court has to say about it. So we're still in court. But yes, I acknowledge that it can be difficult to actually get the government to do this directly. But I think through the legal process, the judicial process, we can achieve, what you want in terms of these kinds of reparations. Thank you.
Thank you so much, Ayo. I will leave the Q&A here. Thank you again to everyone, and I'll pass on to Chris for closing remarks.
Thanks, Camilla, and thank you all so much for joining us today and for all those questions and comments which have contributed to a really stimulating discussion. I'm sorry we couldn't get to all of the questions. As Camilla says, we'll try and respond by email to those that we can. I love these opportunities where we can enable these conversations to take place on these important issues across continents, between continents. And thank you so much to the speakers, to Delia, to Mandira, and to Ayo for their very insightful contributions to this webinar, and to all of you participants for your interest and engagement. And I'm really struck by some of the themes running through the conversation, the emphasis on the need to see survivors as partners in the process, the need for us as practitioners to understand the movement of which survivors are part, the importance of adopting that trauma-informed approach, being transparent regarding our capacities and limitations, and being consistent in our communications with survivors, and the challenge of how we use these reparations processes to empower survivors. Anyway, I think the discussion demonstrates the importance of us all continuing to critically examine the ways in which we seek reparations on behalf of survivors of torture, and to continue to improve our practice of putting survivors at the center of what we do. So we've launched a final poll that you should find appearing somewhere down there in the chat, and we'd appreciate if you would spend just a couple of minutes answering the question before you leave the webinar. But that's the end of the webinar today, so thank you so much again for joining us, and enjoy the rest of your day. Thank you.